Distinguished delegates, my pleasure to welcome you to today's training session. My name is Tobenna Erojikwe, and I am the chairman of the board of the Institute of Continuing Legal Education. The session has actually started, but we're having a few technical issues with having the speakers joining for today. But I'm sure they'll be in the room in a second, and we should all be able to start. But in the meantime, a few housekeeping points. Just want to mention to everybody that whoever wants to drop questions should do so in the Q&A box. Please drop your questions in the Q&A box, because if you drop your questions in the chat box, it might not be picked up. Also, I'm happy that you're all logged in. I would encourage everyone who's logged in to please keep spreading the word. We don't want any Nigerian lawyer to be left behind. We've had impressive figures for this training so far. Yesterday, about 5,800 people joined in on the training yesterday, which is remarkable, from across MBA branches in Nigeria. So thank you for being involved and for participating. We already have 450 people here at the moment. I'm counting, so that is very, very good. I will start now to read the profile of the facilitator for today, even though for some reason he doesn't appear to have joined in at the moment. Akin, please, can you talk to the facilitators and find out where we are with things with them?
Okay. Just give me about 2 seconds. I'll be back. I will confirm.
All right. So I hope that by the time we're done with the citations, they will be in the room at the time. It's my pleasure this afternoon to introduce today's topic, which is post-hearing procedures in arbitration. It is day 3 of the NBA-ICLE training on arbitration. So far, we've had a session with Dr. Chikwendo Madomere, which was an introduction to arbitration generally. And yesterday, we had Professor Daniel Wilmot, who joined us from London, and he spoke on arbitration procedures. So today, post-hearing procedures in arbitration. My pleasure to introduce Mr. Olumide Olushoga Sofowora, Senior Advocate of Nigeria, Chartered Arbitrator. He's a legal practitioner, Chartered Arbitrator, and Notary Public. He is the Principal Counsel and Head of Olumide Sofowora Legal Practitioners, Arbitrators, and Notaries Public, and a practicing arbitrator. He obtained a Bachelor of Laws degree from the University of Lagos in 1981 and was thereafter called to the Nigerian bar in July 1982. After successfully completing a master's degree course in law at the prestigious London School of Economics and Political Science, he was awarded the Master of Laws degree of the University of London in September 1984. He was appointed the Notary Public for Nigeria in 1992 and was admitted a fellow of the Chartered Institute of Arbitrators in August 1998. He became an approved faculty member of the Chartered Institute of Arbitrators UK in 2003 and has been involved in training courses and or assessment programs leading to the award of associate, member, and fellowship levels of the Chartered Institute of Arbitrators. He was elevated to the rank of Senior Advocate of Nigeria in 2013, and based on his experience in international arbitration, attained the status of Chartered Arbitrator of the Chartered Institute of Arbitrators UK in 2017, making him a member of the Institute's panel of international arbitrators. Mr. Olumide Sofowora, Senior Advocate of Nigeria, Chartered Arbitrator, has been active in the activities of the Nigerian branch of the Chartered Institute of Arbitrators UK. He was an executive committee member between 2005 and 2015, during which period he served as membership secretary of the branch and later chairman of the branch annual conference committee between 2011 and 2013. He was involved in a workshop which led to the setting up of the arbitration scheme for banks and was subsequently the chairman of the fundraising and building committee of the branch, which had the responsibility for raising of funds for the acquisition of the suitable property to serve as the branch headquarters in Lagos, Nigeria in 2020. He was, until recently, the regional representative of the Chartered Institute of Arbitrators Nigerian branch. My pleasure to welcome Mr. Olumide Olushoga Sofowora, Senior Advocate of Nigeria, the facilitator for today. Akin will still appear to be having a problem with the learned senior advocate joining us. Please ask that you assign a bit of patience while we sort this out at the back end. Thank you.
Thank you.
Leonard Senior Advocate of Nigeria, Mr. Olumide Sofowora. Thank you very much for joining. Welcome to today's session. We've already done the introductions whilst you were on your way here, but welcome to today's session. I'll be yielding the floor to you now to start. And I hope we'll be able to share your slides. Are you hearing me, Leonard Senior Advocate of Nigeria?
I can hear you perfectly.
Okay, sir. The floor is now yours. Thank you very much for joining us today. Thank you.
No problem. First of all, I want to apologize for joining late. And secondly, just a few hitches here and there. Technical hitches.
Sorry, let's say your screen is only showing us half the screen. So we can only see your full face when you're inclined straight on the camera. I don't know whether someone can adjust it.
Can you see me now?
I can see you clearly, but we're not seeing the full screen. So to see you, you just have to sit straight now and look at the camera. But if someone can help adjust that screen, that will help.
Okay, all right.
Yeah.
I'm trying to
expand the screen. Because I'm trying to wonder why it's showing just half the screen. Akin, is your experience the same as mine?
Yes.
Okay.
Yes, it is.
Okay. I mean, if we're not able to remedy it, we might just have to continue in that wise so that we don't waste more time on it.
Yeah, I think maybe we'll continue. At least we can still see him. We can still see him.
Just a minute.
Apologies for the slight hitch and delay. Hopefully we'll be able to continue in a second.
Yeah. All right. Okay. Well, I don't know what has happened, but let me just go on so that I don't. Well, you can see my full face now, can't you?
You can see your full face, just till about 1/10 of the screen or so, but it's fine. We can see you. Let's go ahead with the training. Hopefully, over time, it gets rectified.
Very well. All right. Once again, I have to apologize for the absence of my co-presenter, Mrs. My technical person is here now. Just a minute.
Just taking them through some housekeeping points while they're sorting you out, right? So impressive. We already have about 1,200 people logged in as we speak, so that's good. Please drop your questions on the Q&A box, not on the chat box, so it can be picked up. The Leonard Silk is just adjusting his camera and we'll be back on very shortly. I just wanted to make the point also that please, those who participate in these training sessions can kindly send in their testimonials to us. What benefits? We're going to be sending out a feedback form very soon so that people can tell us what we need to do better, what their experiences have been, and so on and so forth. But in the interim, those who want to send in their testimonial, I'll drop off where you send it to on the chat box. We are quite happy to see that people are joining in from all the branches in the country, Bukuru, Buheli, and so on. So thank you very much. Hopefully we'll start in a second and then we'll move on from there. Thanks. The picture quality from your end is certainly much better, but we don't have as wide a screen as we would love to. But I think that we can continue nevertheless.
All right.
Yes, please. Thank you.
I can't even see myself. All right. Let me just continue.
I can see that many people are asking for earlier recordings. They're all on YouTube.
Yeah.
The YouTube channel is NBA-ICLE. As far as the course materials are concerned, we'll send them in once the training series is over. So I'll be yielding the floor once again to...
I'm having a seminar now.
Leonard, Senior Advocate of Nigeria, Mr. Sofowara. Thank you very much.
Thank you.
Please, I'm yielding the floor to you now. Thank you.
Thank you. Sorry for all the technical hitches. Unfortunately, you can't see my face as much as I would have loved to see your faces as well. But my paper is a post-hearing procedure in arbitration. And it's going to cover the closure of the hearing, the award, types of award, drafting techniques, form and content, as well as recognition and enforcement of awards, and finally setting aside of awards. Of course, I believe the previous speakers have spoken about introduction to arbitration, as well as the hearing procedure. And now we are going to go to what happens after the hearing. After the close of hearing, the tribunal may, in accordance with Article 39 of the arbitration and, Article 39 of the arbitration rules contained in the first schedule to the Arbitration and Mediation Act 2023, ask the parties if they have further witnesses to call or submissions to make in support of their cases. And if there are none, it will declare the hearings closed. The tribunal may, however, in exceptional circumstances, decide of its own volition or upon the application of a party to reopen the hearings at any time before the award. Now, some international arbitration institutions like the ICC have issued some guidelines on post-hearing procedure in arbitration. And these are, they may proceed to an award without asking the parties for closing statements or what is known as post-hearing briefs. They might also ask the parties for closing statements, but not post-hearing briefs. They might ask the parties to file and serve post-hearing briefs and not closing statements. Or they may indeed ask the parties for both the post-hearing briefs and the closing statements which will be decided at a later date. Now, the essence of all this is to assist the tribunal with the drafting of the final award. Now, post-hearing briefs may be used to draw the attention of the arbitral tribunal to relevant facts that have emerged during the hearing and place them within the context of the parties' claims and defenses. Whilst closing statements may be made orally immediately after the hearing, post-hearing briefs are usually served and exchanged by the final written addresses in litigation, where parties sum up their cases as demonstrated in their presentations at the hearing, with a reference to the hearing transcripts and the analysis of the evidence proffered by the parties. Whilst the benefits of a post-hearing brief is that they will assist the tribunal in rendering the award in cases where there are complicated or disputed facts, numerous witnesses, and extensive cross-examination. The disadvantages are that they will add to the costs of arbitration because of the delay where the facts and arguments are already understood by the tribunal, and these same facts and arguments are being repeated in the post-hearing briefs. So that is usually what happens immediately after closure of hearing. Now, thereafter, the tribunal, either the sole arbitrator or the panel, will proceed to writing of the award. Now, the main object of the award, of course, is to inform the parties to a dispute of the arbitrator's decision. Such decision is expected to be based on reasons deduced from the facts and evidence canvassed by the parties, because perhaps this is what makes the award a very, very important and fundamental aspect of the entire arbitral process. Now, Article 1.2 of the Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958, otherwise known as the New York Convention, defines the term arbitral award to include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies to which the parties have submitted. Now, the term was also alluded to in the United Nations Commission on International Trade Law, otherwise known as the UNCITRAL Model Law, but no specific definition was given. No definition has also been given in our Arbitration and Mediation Act of 2023, nor the English Arbitration Act of 1996. But simply put, an award is a reasoned decision of the arbitrator or arbitrators, which disposes of all issues submitted to the arbitral tribunal, after taking into consideration the evidence adduced by the parties to the reference. An award is complete in itself, and it is a final decision on the matters to which it relates. Sole arbitrators will reflect on the law and arguments proffered before them during the proceedings, but a panel, on the other hand, will have to deliberate more on the matter, with the chairman asking the other members of the panel for their views, and where there is a consensus, a decision will be easily reached. However, where a consensus cannot be easily reached, a majority decision is what will emerge as a decision of the panel. There have also been instances, of course, where you have the three arbitrators holding different views. Usually what happens at the end of the day is that one of them will have to compromise his position or his or her position so that they can reach a majority decision. Now, what are the types of awards that we have? We have the final award, the interim award, the agreed award, interlocutory award, the default award, the additional award, as well as the declaratory award. A final award is said to be final if it is the last act of the arbitrator, which puts an end to the arbitration. It is a kind of mission accomplished, which automatically renders the arbitral tribunal functus officio. This means that all the functions of the arbitral tribunal ceases accordingly. A final award presupposes that all other outstanding matters like costs, interests, and related issues have been properly disposed of. This can be found also in the provisions of Section 48(1) of the Arbitration and Mediation Act 2023. However, there are a few exceptions to the general rule on the finality of an award. One of such exceptions is where the arbitral tribunal can correct, or situations where the arbitral tribunal can correct minor typographical or clerical errors in the award. Now, this can be done suo motu by the tribunal or on the request of one or both parties to the reference. So the tribunal has the power to do this under Section 49 of the Arbitration and Mediation Act of 2023, which states, unless another period has been agreed upon by the parties, a party may, within 30 days of the receipt of an award, and with notice to the other party, request the arbitral tribunal, A, to correct in the award any error in computation, clerical or typographical errors or errors of a similar nature, or where it is agreed by the parties to give an interpretation of a specific point or part of the award. Where the arbitral tribunal considers a request made under subsection 1 to be justified, it shall within 30 days of receipt of the request make the correction or give the interpretation, and such correction or interpretation shall form part of the award. The arbitral tribunal may, that's subsection 3 I'm reading now, on its own volition and within 30 days of receipt of the award, correct an error of the type referred to in subsection 1A. Now I go to interim award. An interim award is usually employed to deal with preliminary issues that occur in the course of arbitration. And unlike in the final award, it does not dispose of all the matters in dispute except those matters it decides. For example, if during a reference, one of the parties raises the question of interim preservation of the rest or the arbitrator's jurisdiction, the arbitrator can proceed to settle the question in the form of an interim award. This is the preferable course of action than having to wait till the end of a long hearing, which might be an exercise in futility, where the arbitrator at the end of the day finds that he has no jurisdiction. Thus, an interim award can save a lot of time and expense for all parties to an arbitration. You can find this in Articles 26 of the arbitration rules made pursuant to the Arbitration and Mediation Act of 2023. Now, an interim award must be distinguished from a partial award. Though similar to an interim award and sometimes interchangeably used, a partial award can deal with a non-preliminary issue like a payment on account, which decision will be final on that issue. If, for example, your claim is that somebody is owing you 100 million naira and he admits to paying 60 million, leaving a balance of 40, the arbitrator or the panel will definitely give a partial award for the amount admitted, and the proceedings will proceed regarding the balance. In other words, part of a decision can be decided and such decision becomes enforceable like a final award, provided it complies with the requirements of the final award. So on the 60 million that's admitted, you can proceed to enforce like a final award. Now, the next award I want to talk about is the agreed award. Sometimes during a reference to arbitration, the parties solve their disputes before the conclusion of proceedings. They then request that the terms of their settlements be made in the form of an award. This is known as an agreed award or a consent award. And you can find this in Section 45(1) of the Arbitration and Mediation Act 2023. It provides that where during the arbitral tribunal proceedings, the parties settle the dispute, the arbitral tribunal shall terminate the arbitral proceedings and shall, if requested by the parties and agreed to by the arbitral tribunal, record the settlement in the form of an arbitral award on agreed terms. Section 47 of the Arbitration and Mediation Act 2023 also requires that an agreed award must meet the same criteria as a final award. It must be in writing, must be duly signed by the arbitrator or the arbitrators, and include the date and place of the arbitration. The major advantage of an agreed award is that it can be enforced just like a final award, unlike the ordinary terms of settlement, which requires a further act of obtaining a judgment of the court. Now, we also have the interlocutory award. Sometimes an arbitral tribunal is called upon to determine a procedural question during an arbitration. An example is the order in which witnesses and experts are to testify in an oral hearing or the timetable of pleadings. A decision in this regard is called an interlocutory award. Whilst Article 32(1) of the arbitration rules of the old Arbitration and Conciliation Act 1988 specifically provides for the tribunal to make interim interlocutory or partial awards in addition to final awards. Article 42(1) of the Arbitration and Mediation Act of 2023 is broader in stating that the arbitral tribunal may make separate awards on different issues at different times. So it's not limited to partial, interlocutory, or interim. The panel or the sole arbitrator now has the ability to make separate awards on different issues at different times. However, it should be noted that an interlocutory award is not enforceable like a final award. Default award. Where a party to an arbitration fails, refuses, or neglects to participate at the beginning of the proceedings, what should happen? Or supposing the party participates at the beginning, but refuses to do so without sufficient cause. In such a circumstance, the arbitral tribunal can continue with its proceedings and give its award in the absence of the defaulting party. This is what is known as a default award. Default in the sense that it is ex parte. And this can be found in section 41B of the Arbitration and Mediation Act of 2023 and section 41(1) of the English Arbitration Act of 1996. Now, this doesn't, however, relieve the active party of the duty to prove its case where the hearing is oral or furnish enough documentary evidence where it is documents only. The import here is that the arbitral tribunal must still endeavor to satisfy itself that the active party had proved its case before giving an award in its favor. Such an award can be enforced against the defaulting party. So the fact that a party stays away, particularly a respondent stays away from an arbitral process, does not oblige the claimant to refuse to prove its case. It must still prove its case so that it can be clear that it definitely has a proper case sufficient to justify the award by the sole arbitrator or the panel of arbitrators. Now, the next award I want to talk about is known as the additional award. And the section 49(4)-(7) of the Arbitration and Mediation Act 2023 provides that unless otherwise agreed by the parties, A party may, within 30 days of receipt of the award, request the arbitral tribunal to make an additional award as to the claims presented in the arbitral proceedings, but omitted from the award. 5, where the arbitral tribunal considers a request made under subsection 4 to be justified, it shall, within 60 days of the receipt of the request, make the additional award. Subsection 6 states the arbitral tribunal may, if it considers it necessary, extend the time within which it shall make a correction, give an interpretation, or make an additional award under subsection 2 and 5. And 7, the provisions of sections 47 of this act applies to any correction or interpretation or to an additional award made under this section. Article 47 of the Arbitration Rules of the Arbitration and Mediation Act 2023 contains a similar provision to section 49 of the Arbitration and Mediation Act 2023. The combined effect of these two provisions affords an arbitral tribunal that has omitted to pronounce on some claims while making an award the opportunity to do so in the form of an additional award. This will naturally save a lot of time and expenses that will have been dissipated in commencing a fresh proceedings on the omitted claims. Now, the last but not the least, of course, the last that I have is known as a declaratory award. Now, where an award merely pronounces on the rights of the parties and no more, it is regarded as a declaratory award. This kind of award is usually employed where declaratory relief is sought by the parties in order to avoid jeopardizing a long-term business relationship. Now, this situation is best illustrated by the case of Saudi Arabia government versus Arabian American Oil Company, Aramco, as reported in 1963, 29 International Law Reports at page 117. At page 145, the court held, I will come to that holding later, but the facts are that in that case, Aramco had an exclusive right to transport oil from its oil fields in Saudi Arabia. Later, the government of the Kingdom of Saudi Arabia entered into an agreement with the company of the Greek shipowner Aristotle Onassis for a similar transaction. Aramco claimed that its concession had been infringed by the later agreement, but the Saudi Arabian government felt otherwise. The matter became so protracted that they had to go to arbitration. However, since both parties did not want to jeopardize their long-standing trading relationship, it was agreed that the matter be referred to an ad hoc arbitral tribunal in Geneva. Both parties then agreed that the award should be declaratory only as to the rights of the parties and not their liabilities. Tribunal had the following to say, amongst other things, on page 145. There is no objection whatsoever to parties limiting the scope of the arbitration agreement to the question of what exactly is their legal position. When the competence of the arbitrators is limited to such a statement of the law and does not allow them to impose the execution of an obligation on either of the parties, the arbitration tribunal can only give a declaratory award. So just like we have in litigation that you can go by way of declaration to actually assert your legal rights to your claims before the court, so also the way have declaratory awards being rendered where parties are agreed as to their rights, but not as to their liabilities. Now, what are the drafting techniques that arise in the preparation of an award? Now, there is no right or wrong way in drafting an award. However, it is usual to start by identifying the statute under which it is made and the applicable arbitration rules. Next is the identification of the parties, details of the dispute out of which the arbitration arose from, any special circumstances relating to the dispute, including dates, should be stated. Reference should be made to the arbitration agreement. Some arbitrators actually quote the arbitration agreement in full in the award. The manner of the arbitrator's appointment will then be set out, followed by details of preliminary meetings, and any interlocutory procedure undertaken before the hearing. Now, if there had been earlier awards given in the course of the reference, they will need to be identified. And next will be the details of the hearing, if there was one. This will include dates, details of parties, and their counsel who took part. Now, having completed the introduction and the recital, it will be necessary to address the matter in dispute, preferably issue by issue. The evidence connecting the issues, findings of facts, and the reasons for the decision. If there are legal authorities cited, they should be considered and legal precedents followed. The award will then be concluded with a summary of any money awarded, including interests and costs. It must be borne in mind at all times that the law requires an arbitrator's award to be enforceable, satisfactory, and conform with all the requirements of appropriate legislation. It must also conform to legal principles and relevant decided cases and custom. Hence, it is important that an arbitrator should master good drafting techniques. Part of this is acquired through training and experience. Now, what are the forms and contents of an award? So after knowing the drafting techniques, what will the award contain? Article 31 of the Arbitration Model Law provides that 1, the award shall be made in writing and shall be signed by the arbitrator or arbitrators. 2, the award shall state the reasons upon which the award is based, unless the parties have agreed that no reasons are to be given, or the award is an award on agreed terms under Article 30. Sub-Article 3 states, an award shall state its date and place of arbitration as determined in accordance with Article 21. The award shall be deemed to have been made at that place. Now, the above provision of the article, that is Article 31 in the Arbitration Model Law, is almost in pari materia, or almost identical with the provisions of Section 47 of the Arbitration and Mediation Act 2023. Thus, apart from being in writing, an award must give the reasons for the award, except agreed otherwise by the parties. So if the parties say they don't want any reason, then of course, there is nothing anybody can do about that. The award must be signed by the arbitrator or the arbitrators, must be dated, and the seat of the arbitration noted on it. It is usual but not compulsory to have the signature of the arbitrator witnessed. So in some cases, you may have, particularly in a lot of international jurisdictions, you may have, international arbitrations rather. You may have the signatures of the arbitrator witnessed by a notary public and to give it more authenticity. Furthermore, the heading of the award will usually identify the parties, while the reciter will recapitulate the background and details of the dispute in question. An award is complete when it is published and notified to the parties concerned. The date and seat of the reference is important for the purpose of time within which to set it aside, if the need arises and enforcement, if the need arises, and so also for the purpose of enforcement, respectively. Now, in addition to the above formal requirements, the law requires that an award should be complete, certain, final, and capable of enforcement. Complete in the sense that the decisions reached by the arbitrator or the arbitral tribunal must logically flow from the evidence adduced. It must then completely decide all matters in disputes. Certainly, the certainty of an award means that all issues in dispute must be disposed of, including issues like costs, interests, and so on. Also, specific findings must be made on each head of claims. The nature of the enforceability of an award requires that it must be reasonable, legally satisfactory, and capable of being performed. Sufficient background must be given, and evidence presented must be logically reviewed to set the scene for specific findings on the issue in dispute. Now, delivering a paper titled Differences Between a Judgment and a Reasoned Award, Lord Bingham, the Lord Justice of England and Wales, said as follows: "It is not incumbent on an arbitrator in stating reasons, and again, probably not desirable, to give an assessment of the witnesses and a detailed statement of his grounds for preferring the evidence of A to B, or the expert evidence of C to that of D. These are not matters subject to the review of the courts, and so reasons of this kind are not called for under the Act. The arbitrator must say as much or as little as he thinks necessary for the enlightenment of the parties. To that end, it is sometimes helpful to state that the evidence of a particular witness or witnesses was not accepted. What documents the arbitrators choose to annex for the purpose is a matter for them. An arbitrator is not called upon to make any detailed analysis of the legal principles canvassed before him or review the legal authorities cited. It is enough if he briefly summarizes the arguments put to him and expresses his legal conclusion in a way that makes it intelligible." So that is Lord Bingham in the paper titled Differences Between a Judgment and a Reasoned Award. Thus, an arbitrator is not only required to briefly note the evidence proffered and the submissions made thereto, he should then note the issue of common ground and the issue in dispute. Each is then considered in turn and findings of fact made. If there are legal authorities applicable to the facts, they are considered, and then a final decision is given. The award need not be verbose and long-winding or likened to a judgment of a regular court. In the case of Trans Catalana, in Cobrasa, reported in 1995, one Lloyd's report, page 215. Mans J had this to say on what not to do in writing an award. The present award is imbalanced between recitation on the one hand and findings and reasoning on the other. It sets out great length messages exchanged between the various parties, many of them containing assertions of fact raised as disputes evolved, as well as the parties' respective submissions to the board on numerous issues of fact and law. But its reasoning and finding on liability are limited to one issue and are of the utmost brevity. More particularly, the award extends over 41 pages, divided into sections headed the contract, the facts, appellants, sellers, submissions, respondents, buyers, submissions, and submissions as to the law and GAFTA provisions applicable. And concluding with the section of findings and the award, the facts extends over 18 pages, consisting mainly of verbatim recitation of messages passing between the parties. The sections on submissions comprise 15 pages, recounting arguments and submissions on facts. By contrast, the essential findings and reasonings on liability extend to 12 lines. So it is clear that this is not the manner in which an award is to be written. The recitation itself is almost about 30 out of, it's about almost 40 pages, because you only have 12 lines of the reasoning, which is what is important. Now, is there a time limit within which to issue an award? In the absence of anything to the contrary, an award is expected to be made within a reasonable time. Where, however, a time limit is imposed, a time limit must be observed, as an arbitral tribunal will no longer have the jurisdiction to continue after the expiration of such time. Therefore, anything done outside the time limit provided for in a reference will be an exercise in futility, as it might be null and void in the absence of an extension of time before its expiration. So if you know that you're running out of time, the best thing is to call the parties and agree as to how time could be extended. However, in some countries like the United States of America, time limits will not invalidate a late award. The point was illustrated in the New York case of State of New York Department of Taxation and Finance versus Valenti, reported in 393 NYS 2D 797, where the court held that an award made outside the limited time was not invalid, as nobody was prejudiced in the circumstance. Time limit makes for speedy determination of an arbitration. Time limits can be imposed by the arbitration agreement, rules of an arbitral institution, or by the provisions of any legislation relevant to the arbitration. For example, the ICC rules limits the time for making an award to within 6 months of the date of signing the terms of reference. In the case of American Arbitration Association rules, an award must be rendered within 30 days from the date of closing the hearings. A major drawback in limiting time for an award is that it can truncate the whole arbitral process at the end of the day. If in the process, a party is not given enough time to present its case, or some other procedural error occurs as a result of an arbitrator being in a hurry to conclude the reference. Now, what are the salient points to note in rendering an award, aside from the ones that we have mentioned? Now, the very important one is notification. Once an award is made, it is mandatory that signed copies of such award must be forwarded to each party to the reference by the arbitrator or the arbitral tribunal. This is contained in section 47(4) of the AMA. Says a copy of the award made and signed by the arbitrators in accordance with subsections 1 and 2 of this section shall be delivered to each party. Now, Section 55(1) of the English Arbitration Act 1996 states that the parties to the arbitration are free to agree how the award should be notified. If there is no such agreement between the parties, then recourse is had to Section 55(2), which states that the award shall be notified to the parties by service on them of copies of the award, which shall be done without delay after the award is made. This is known as notification of the award, and the relevant date here is not the date of the award, but the date on which it was notified to the parties. In other words, for the purpose of taking steps against the award, time will not begin to run until the award is notified to the party. However, a novel provision included in the new Arbitration and Mediation Act 2023, which now specifically allows tribunals or arbitral institutions to exercise the right of lien on the award where there is outstanding payment due to the tribunal or arbitral institution on account of fees and expenses due to the tribunal or the institution. This can be found in Section 54(1) of the Arbitration and Mediation Act 2023. Previous to this, there has always been a problem because parties will say it is immoral and illegal for an arbitrator who has not been paid to lien or to hold on to the award without publishing it to them after a hearing is concluded. But this has always generated a lot of controversy. And you find that most arbitrators will always want to ensure that at least they have almost 60 to 70% of the fees due to them paid upfront, so that they'll be assured that they will not have worked in vain at the end of the day. But you still find parties complaining. But now, thank God that we have Section 54(1) in the new Arbitration and Mediation Act, which says the arbitral tribunal or any arbitrator has a right to lien the award until his payments, until his fees and expenses are paid. I'm particularly happy about that. I don't know about you people, but now res judicata. Just like in a regular case decided by the courts, the doctrine of res judicata will apply in an arbitration that disposes of all the issues. If an unsuccessful party should bring an action in a regular court on the same subject matter dealt with in an arbitration, res judicata will be a valid defense and the court can dismiss the action on that basis. An invalid award, now this is arbitration, an invalid award which has been set aside will not operate as res judicata in subsequent disputes that arise between the parties, since the doctrine of stare decisis is not applicable to arbitration. A previous award of an arbitrator will not be binding in subsequent disputes that occur between the same parties. Now, interest. Where the terms of the contract provide for the payment of interest on money which is past due, interest will naturally be recoverable. This type of interest is known as contractual interest, where, however, there is no specific provision for interest in an agreement. The power to award interest must be exercised judiciously and judicially, taking into consideration the surrounding circumstances of each case. In the case of Panchard versus Pagnan, 1974, One Lloyd's Report, page 394 at 411, Lord Denning put the law succinctly as follows. In a commercial transaction, if the plaintiff has been out of his money for a period, the usual order is that the defendant should pay interest for the time for which the sum has been outstanding. No exception should be made except for good reason. In Nigeria, the new Arbitration and Mediation Act 2023 specifically provides for the award of interest in section 46 thereof, on the circumstances in which it may be awarded, as well as the principles that will guide the tribunal in the award of interest. It must be noted that the law of some countries, particularly in the Islamic world, forbids the award of interest. Some other jurisdictions view the issue as purely procedural, as against others that regard it as a substantive matter. It is instructive to be familiar with the laws of various countries regarding interest, so as not to run into stormy waters during enforcement. For example, if a provision in the law of a country of enforcement of an award prohibits or treats as usurious a specific award of interest, then such a provision may afford a ground or refusal of enforcement. This is also provided for in Article 5(2)(b) of the New York Convention. Now, costs. In making an award, an arbitrator is expected to deal with the liability of the parties with regard to costs. Costs here means costs of the arbitral tribunal and cost of the parties. The cost of the arbitral tribunal includes the arbitrator's fees and administrative expenses. On the other hand, the costs of the parties include not only legal fees of counsel, but also fees for experts, witnesses, traveling, telephone, and other incidental expenses. The general rule on costs of the parties is that costs follow the event, but where there are costs on counterclaims that succeed, then the arbitrator is expected to assess this as well. Under the Arbitration and Mediation Act 2023, costs are provided for in articles 48 to 51 of the arbitration rules. And also you can find the issue of costs being dealt with in section 61 of the English Arbitration Act 1996. Now, in apportioning costs, the arbitral tribunal has a discretion. There have been no universally established practice as to the manner in which that discretion should be exercised. An arbitral tribunal will be guided by the extent of success and conduct of the parties. Where, for example, a party is successful in a head of claim, but has sufficiently delayed the arbitral process, sufficiently that the other side has incurred more costs, then, of course, the tribunal has the power to assess the costs, and the successful party may end up not getting the entirety of what he has claimed. Now, on general reliefs and remedies, the Arbitration and Mediation Act 2023 does not specifically provide for the kind of relief and remedies which an arbitrator can provide in an award. As common law, however, the relief of declaration, payment of money, injunction, and specific performance, amongst others, are available to an arbitrator. Hence, an arbitrator conducting an arbitration under the AMA 2023 can grant this as well. In the English Arbitration Act 1996, there's provision in section 48 that incorporates the common law situation into its own provisions. Payment of money. This is by so far the most common relief or remedy available in awards. Just as it is, a sum of money is ordered to be paid by one party to the other. This hardly needs any further explanation or illustration. So it could be by way of a declaration. This was touched upon earlier, where various types of awards was explained. A declaration can only be recognized as it is not enforceable. Injunction, it is a known fact that arbitration does not possess its own separate machinery of the enforcement of awards. This is done through the machinery of the courts. By the same token, any injunction granted by an arbitral tribunal in an award can only be enforced with the machinery of the regular court. Specific performance, this relief is available to make a defaulting party to a contract to perform same. It is, however, not applicable to interests in land. At the end of the day, the assistance of the machinery of courts might be needed to enforce it. Of course, interest and costs is another relief that I've already discussed above. Now, let me come to the issue of recognition and enforcement of awards. Generally, a successful party in an arbitration would want to enjoy the fruits of his success. Hence, if an award cannot be enforced at the end of the day, then it is useless. Where a losing party refuses to or neglects to comply with an award, the machinery of the courts can be employed to levy execution on the assets of the said party. The mechanism for enforcement differs from one jurisdiction to the other and country to country. In some jurisdictions, once an award is registered in the court, it becomes enforceable as a judgment of that court. You can see Section 57 of the Arbitration and Mediation Act 2023. Yet, in some other jurisdictions, you can enforce an award directly without registering it with the court. Yet again, in some others, you need to bring an enforcement proceedings before the court to enforce an award. The difficulty here is that an unscrupulous defendant may raise the defense and try to reopen the entire arbitral process afresh. Thus, arbitration awards can be enforced in most countries of the world, provided that those countries are signatories to the Geneva Convention on the execution of foreign arbitral awards or the New York Convention on the recognition and enforcement of foreign arbitral awards. Article 1.1 of the New York Convention provides that this convention shall apply to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought, and arising out of differences between persons, whether physical or legal. It shall also apply to arbitral awards not considered as domestic awards in the states where their recognition and enforcement are sought. The New York Convention, which replaced the Geneva Convention, has been applauded as the locus classicus, or a watershed in international arbitration, because it provides a much more simple and effective method of obtaining recognition and enforcement of foreign awards. It is to be noted, however, that the enforcement of an award can be refused on the ground that it is against public policy of the country where it is sought to be enforced. Similarly, where there is lack of jurisdiction on the part of the arbitrator, or there was procedural irregularity and lack of fair hearing during the conduct of the arbitral process, amongst others, then the enforcement will be refused. This is provided for in Section 58 of the Arbitration and Mediation Act 2023. It should be noted that the convention does not apply to domestic arbitration. It only applies in international arbitration. Now, I come to the final point on this issue, which is setting aside of arbitral awards. Now, an arbitral award is not appealable in the regular courts. It can only be set aside for reason of misconduct or other procedural irregularity by the courts. This is provided for in Section 55, subsection 3 of the Arbitration and Mediation Act 2023. Section 55 provides that recourse, subsection 1, recourse to a court against an arbitral award may be made only by an application for setting aside in accordance with subsections 3 and 4. 2, an application for setting aside an arbitral award shall not be made on the ground of an error on the face of the award or any other ground except those expressly stated in subsection 3. Now, subsection 3 states the courts may set aside an arbitral award where the party who makes the application furnishes proof that a party to the arbitration agreement was under some legal incapacity. 2, the arbitration agreement is not valid under the law to which the parties have subjected it, or failing such indication under the laws of Nigeria. 3, the party who makes the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise not able to present its case. 4, the award deals with the disputes not contemplated by or does not fall within the terms of the submissions to arbitration. 5, the award contains decisions on matters which are beyond the scope of the submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not submitted, only that part of the award contains decisions on matters not submitted to arbitration may be set aside. 6, the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, unless the agreement was in conflict with the provision of this act for which the parties cannot derogate. 7, where there is no agreement between the parties under the subparagraph, then 8, that the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the Arbitration and Mediation Act. Now, B, where the court finds that 1, the subject matter of the dispute is otherwise not capable of settlement by arbitration under the laws of Nigeria, or the award is against public policy in Nigeria. Subsection 4 states, an application for setting aside shall not be made after 3 months has elapsed from the date on which the party making the application has received the award, or if a request has been made under Section 49 of this Act, from the date on which that request has been disposed of by the arbitral tribunal. Subsection 5 states, where the court is satisfied that one or more of the grounds set out in subsection 3 has been proved, and that it has caused or will cause substantial injustice to the applicant, the court may remit the award to the tribunal in whole or in part for reconsideration, or B, set the award aside in whole or in part. Subsection 6, the court, when asked to set aside an award, may, where appropriate and so requested by a party, suspend the setting aside of the proceedings for a period of time determined by it, in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take any other action which, in the opinion of the arbitral tribunal, will eliminate the grounds for setting aside. I made reference to 2 cases. In concluding, I made reference to 2 cases. Kano State Urban Development Board versus Fans Construction Limited, reported 1990. Nigeria Weekly Law Report, Part 142, page 1 at 43. Where the Supreme Court, Agbaje GSC, held, while delivering a lead judgment, that where an arbitrator or umpire has misconducted himself, or an arbitration or award has been improperly procured, the court may set aside the award. Also, there is the case of Taylor Woodrow Nigeria Limited versus SGMB, reported 1993 for Nigeria Weekly Law Reports, Part 286, page 129, at 141 to 144. And also Baker Marine Nigeria Limited versus Chevron Nigeria Limited, 2012 NWLR, Part 681, at page 393. Here endeth the lesson. Thank you. So, Bena.
The National Advocate of Nigeria, Olumide Sofore. I am here, sir. Thank you very much What a brilliant presentation, extremely well researched, and shows a lot of practical experience. I was thinking about how difficult it would be to deliver this kind of very technical paper, but you did it with such ease. Thank you very much, Musa. Thank yous at the end. I'll just invite Akino Misade to take question time, and then compliments will follow at the end. Thank you very much, sir. Great.
Well, before it starts, I'm sorry. My slides are ready, but they couldn't come in because I was making my delivery. So, but maybe I'll send soft copies later to those who may need it.
Thank you, sir. There's been a very hot demand on the comment section for the paper. So thank you for that confirmation. And I'm sure they will be more delighted to have heard it from you than myself. So thank you, sir. Akin.
Yeah, thank you, Tobena. And Leonard Silk, it couldn't have been much easier than that for you to deliver. I'm sure even without the slides you would have done a wonderful job to the session of post-hearing procedures. The questions are still coming in fast and thick. I hope we'll be able to take all these questions. So far, we've had, in their tens now, so far, wow. In the moment I've been speaking to you, we've had in the flurry about 10 questions so far. Okay, so I'm going to, Leonard, I'm going to be taking you up on some of the points you have delivered. Thank you very much. The role of a sole arbitrator is a very lonely place. After when he retires or when he or she retires, to consider and write a reasoned and enforceable award. Can you, in a nutshell, explain what happens when arbitrators actually retire? After several days of hearing, what actually happens? What, as a chartered arbitrator, what is it like? We know judges retire or justices do retire and consider. What is it like as an arbitrator when you retire?
Well, of course, all your faculties must be alert. It is normal for you, where the arbitration is a big one, to exercise some trepidation as to how to start. But once you've been able to get a grasp and follow the usual guidelines that have been set out in most arbitral resources on drafting techniques, it's going to be very easy for you to actually sit down and write a very reasoned award. Usually, these days, we find that arbitrators tend to write their awards in the form of judgments, which is what is usually frowned at internationally. But yes, you can hardly avoid it, because there are times that a lot of litigation lawyers who are used to reading judgments will usually want to flow along the lines of the judgments that they have written. That they have read, rather. But in the case of I've read of situations where those who are writing awards for the first time usually have a very serious difficulty, because they will go about asking questions of those who probably mentored them. How do I do this? How do I do this? Of course, it has to be pointed out that arbitration is a very confidential process. And some goes to the extent of asking, this is what happened, this is what happened, and expect you to actually give them tips on how to write the award. But by the time you write one, By the time you go to the second one, by the time you write the third one, after some time, it becomes an easy task for you. And you discover that you're able to actually write an award, not necessarily a good and reasoned award, not necessarily one that will be too technical. In the process of even writing awards, you could run into the problem of going beyond your scope. And that itself would be a ground for misconduct. So it's better you just make it safe and simple so that you don't run into any problems whatsoever.
Okay. Thank you very much, Leonard. I know as Secretary of BOSAN, you are very familiar with AMA as well and the legal process. And there's a question that has been recurring, and I want us to put it to bed very, very quickly. And the AMA has been, we all have the AMA 2023 now, but there's a small issue. It has not yet been gazetted. Can we, strictly speaking, be referring to it? Can we use it as a basis for arbitration proceedings or procedures, or we are still dependent on the 1988 Act? So.
Well, my understanding of the position is that once a bill has been signed into law by the president, from that moment, it becomes the law of the land. The issue of gazetting, I think from our own little experience at the bar, is only a formal process. Because I remember there's a case, I can't remember the citation now, but it is very clear that all the steps towards ensuring that the act has passed through the relevant stages in the National Assembly have succeeded. All that remained was for the presidential assent. And since it was signed, from that date onwards, as far as I'm concerned, that is when it becomes law. I mean, just as well as saying, okay, because it has not been codified in the laws of Nigeria or laws of the Federation, therefore it cannot be applicable. No, I don't think that's the law. I think the fact that the president has signed it, it has become law and should be applicable immediately.
I think that answers a lot of the questions we've had for 2 days.
That's why I actually made a lot of reference to it in this paper.
Thank you very much, Leonard. Now, there's another question, and the scenario is this. You know, when in a 3-man panel that you will have, the party A is appoint, and party B appoints, and the 2 party-appointed arbitrators will now make the appointment of a presiding or the chairperson. During the deliberations by the arbitrators, because the arbitrators will deliberate, you did make mention that one of the arbitrators may have to compromise. That was the word you used. They may have to compromise to allow a majority. The question is, if one of the party-appointed arbitrators has to compromise to allow a majority, would that not be detrimental to the party that has appointed that arbitrator? That is one. And could that not lead to a situation, because from experience, it is stated that when the arbitrators are deliberating, the party-appointed arbitrator can shed light on his appointer's case to give explanation. So when you use the word compromise, does that not put that party-appointed arbitrator in a compromising position? That's the question.
When I use the word compromise, I don't mean compromise in the sense in which he's supposed to compromise his client's case. Oh, sorry, his party-appointed, the case of the party that appointed him. No. As a matter of fact, the fact that a party appoints an arbitrator does not mean that the arbitrator is supposed to be the party's representative at on the panel. He has to be independent and impartial, irrespective of what happens. So he will not be compromising the case of his appointee, because that is usually what happens. A lot of arbitrators in a panel will usually want to defend the person who appointed them, but ordinarily, it is in the code of conduct of arbitrators that you know that even if somebody has appointed you, it does not mean that you have to support that person's case. You're supposed to be independent and impartial. And this is where the issue of conflict of interest and things like that come in. Now, the context in which I used actually the word was because where you have the three arbitrators in a panel towing different lines, then of course they cannot reach, there will never be a majority decision. So what I meant was one of them, it may not even be any of the two party appointed arbitrators. It may even be the presiding that will have to actually say, okay, I think I'll rather go more with my fellow arbitrator who has said we should grant the claims of the claimant, or he might decide to say, okay, I've looked at the whole matter again, and I agree that I think I would rather support the case of the respondent who has put up a perfect defense as to maybe one issue of all the issues being considered. So that's the context in which I mean it. But don't let us mix it up with the issue of who appointed who. It is that way. It means that then, of course, the issue of independence and impartiality will be lost.
Right. Thank you very much for that explanation. Now we're going to. There's been a number of questions on where we have a three-man panel and what will happen. And these are practical instances that I think your wealth of experience will definitely assist us. You mentioned an additional award. You've had a final award. In between the final award and the request for an additional award, one of the arbitrators passes on. And this is a situation that could happen. How will the tribunal deliver or publish that additional award?
That's a tough one. Where a party dies,
where one of the arbitrators dies between
the time of
the final award and the additional
publishing
award.
the award.
Yes.
Well, in a three-man panel, of course, if the two remaining arbitrators are majority, there will be no problem if they agree. That means you have two arbitrators who have agreed on the decision that was made. But the situation that may create a problem with where the two of them are opposed to one another and do not agree in their deliberations, then of course it throws up a very serious issue. I mean, the essence of arbitration is to save time and costs, and you cannot actually say they should start all over again. But honestly, having raised that issue is one thing I have to actually consider myself, because I've never heard of it happening before. So we'll have to look at it and see how we can. I will look at the authorities and maybe add it to when I'm going to forward bring it up as one of the questions I'll have to answer, because I know I can't answer all the 50 questions that I see on the screen, that have arisen on the screen.
And they're still
maybe
coming.
I'll have to ask them subsequently. Go on.
Thank you very much. Now, I think this one is very easy for you to answer immediately. When you write a reasoned award, you've talked about default awards, you've talked about interim awards. The question is, do you have to head it a default award or just award. Can you hear me, Leonard, sir? Can you hear me, sir?
You broke off a bit. I didn't hear you. Can you repeat your question?
Oh, right. The question is, do you have, if you have a default award, do you have
Yes.
to?
Appears to be frozen out. Everybody appears frozen. Can you hear me?
Hello.
Okay, I can hear you now.
Hello. Where's Aki?
You appear to have been frozen out earlier. Are you still there?
Right.
I'm still here. But I don't know where Aki is.
So I'm still here. I don't know what happened. I said, if you have, the question is, if you have, you mentioned a default award, and the question is, must you title it a default award?
Well, why not? If you want to, awards come in various forms. If you title it a default award, it clearly shows what it is. I mean, I have written certain interim awards before, and I headed this interim award. So it really doesn't matter how it is headed. The important thing is an award has been handed down, and the provisions are there in the law as to what should happen in the event of a default award. Of course, the respondent must have been given several opportunities of coming to defend the claim. And if it doesn't show up, just like we have in courts, we have default judgments. I mean, there's nothing wrong in heading it whichever way you want. It doesn't affect the essence of what has happened.
Right. Thank you very much. Now, there's I mean, you are a courtroom gladiator, and you are wearing the stripes of a courtroom gladiator. Can you hear me, please? Can the learned?
You are quite audible, so I'm sure that, but I can't find Leonard. Okay, Leonard can hear you. Right.
Can you hear me?
Perfectly. I can hear you.
Me. Oh,
I can hear you.
Oh,
yes.
Oh, all right. I didn't. So there's a question here that I said you're a courtroom gladiator, and
I don't know what that means, but go on.
The question now is, we have final written addresses in our jurisdiction here, and
yes,
are they the same? And if they are not the same, can you shed some light on the differences in them? Leonard, are you still there? Is the Leonard still there?
I think, Tobena, you can hear me, can't you? Tobena, can you hear me? Hello?
Leonard, I can hear you.
Oh, okay.
Aki, I think you're the one that has issues with your
Okay.
Go ahead. Let's see whether we can hear you.
Yeah, Leonard, go ahead.
Yes, you said you want to know the difference between final written address and what? Hello? Can you hear me? Hello? Hello? Hello, 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 hello. Can you hear me?
Yes, sir, we can hear you.
Can you hear me? Okay, I can see Peace Adile, you can hear me.
I can hear you too, Leonard, so that's fine.
We can hear you, Leonard.
Okay, thank you. Akin,
Oh, you see.
Akin, what is the problem with yours? Akin has gone off again.
I think it's locking somewhere in the background there. Yeah, he's there. Leonard Singh, did you get the question from Akin?
No, I did not. I only heard what's the difference between final written address and something. I don't know what the other thing was.
Closing brief. Closing briefs.
Oh, you mean post-hearing briefs?
Yes. Well, he called it
Okay.
closing.
Yes, like I said, we don't have such procedure in Nigeria. It actually, I know that it operates in a lot of international arbitrations, particularly by I know the ICC Commission on Arbitration and ADR actually has it as one of the guidelines that they issue out to the parties. And the post-hearing brief is similar to our usual final written address in litigation, because then, of course, the analysis of the case, the complete presentations at the hearing, and reference to the hearing transcript and things like that are presented, just like we have in the final written addresses. And that is what makes it different from a closing submission. A closing submission, on the other hand, is usually the oral aspect of, usually when you file, when you finish your hearing, parties will normally, just like in courts, will say, my lord, we want so many number of days to file a written address. So in arbitration also, in some cases, right from the beginning, what I always do is, the moment we are doing the preliminary meeting and we're fixing the dates for hearing and everything, we also include the dates for the exchange of final written addresses, which is equivalent to the post-hearing briefs, so that we don't have to come back again. As soon as we finish, you just say, okay, you say you're going to file by order so and so in order for directions number this. You are given so many number of days to file your final written address, as the case may be. Are you still standing by that? Yes, Honorable Arbitrator, I will file and serve. I will serve within 14 days, and the respondent starts, of course, and the claimant will say, I will also do mine within 14 days thereafter. And so that as soon as they finish, unless you want them to now come for closing submissions, which may not be necessary, since you're supposed to take what they have stated in their final addresses as what they are likely to come and adumbrate upon, then you just go ahead and say, okay, we'll notify you, or we'll publish the award. You can even agree if it's convenient within so and so number of days, or you can tell them they will expect it within at a particular time or whenever they receive it. So that's it. So a final address in litigation is similar to the post-hearing brief in arbitration.
Okay. Thank you. And there's another question that says here that can an arbitrator, after the close of hearings, still open the hearing, reopen the hearing?
Yes.
If the answer is yes, what is the procedure? Especially in a situation where a party fails to appear, it does not appear until after the close of hearings. I'm sure that this takes into account that there's been opportunity and not given to that party to attend. But now turns up so late in the day and requests for an opportunity to present its case.
Since the award has not been rendered or published, there are a lot of measures that can be taken by the arbitral tribunal. Of course, it cannot just come in, it has to be by application. And the application will probably state the grounds which must be exceptional, upon which the party who has been away and who suddenly surfaces wants the matter to be reopened. Usually, I know that the arbitrator or the panel will usually lean in favor of ensuring that they give the party an opportunity to be heard. I know there's a section in the Arbitration and Mediation Act, is it 51(1) or something, or is it the articles that says the arbitral tribunal shall do all within its power to ensure that it does all in its power to ensure that a fair hearing is given. So under that article, I think if a party makes an application, usually the tribunal will bend over backwards to want to accommodate such party. Of course, it will not be free. The party will be penalized in costs at the end of the day, because it's going to cost a lot of money to reopen an arbitration that has been concluded. So those are some of the things that I think the claimants would want to use. Yes, okay, I don't mind. You can come in. I know I have my case is solid as a rock, but it's going to pay me so much as costs, because, I mean, where was he all the while, you know? But that is usually what arbitration is, to resolve the matter between the parties without, by giving equal and fair opportunity for parties to present their cases.
Right.
That's what I would.
Okay, thank you very much, Nancy. This is a question that I think even experienced practitioners may find somehow confusing at times. And this is the issue of seat and place of arbitration. And the question is it right or acceptable to use Nigeria as a jurisdiction, the English law as the applicable law?
Well, usually we've had a lot of issues that arise from matters of this nature, where, for example, I think I still raised, the issue came up about 2 weeks ago when we're having a maritime seminar for judges. And the issue arose as to which law will apply, where there has been a breach of the charter party, and there's an arbitration clause. And most of the charter parties will say that the arbitration will be in terms of the London Maritime Arbitrators Association rules. A lot of problems that arise, usually because Nigeria is seen as a place where there's a lot of issues in terms of ensuring that just a minute, please. I'm sorry about that. Where the seat of arbitration is in Nigeria, of course, the parties by agreement may say they want to have the arbitration in London. That, of course, takes a lot of, it's not beneficial for Nigeria in terms of commerce and integrity, if you can use that, because there's nothing wrong in us having Nigeria as a seat and having the arbitration done in Nigeria in accordance with Nigerian law, which may be what must, of course, be what may have governed the transaction or the contract of the parties, you know. So, but it continues to be a recurring issue in international commercial arbitration. And usually parties are bound by what they have agreed to in the arbitration agreement. But honestly, I don't see why not. I mean, Nigeria with the new AMA now, it's wide enough to cover all instances. And I think we should lean towards doing more in that regard.
Yeah, thank you very much. This is a practice question, which I think we'll all benefit from. You have today, I've heard you address you've called the arbitrator honorable arbitrator. And this is a question, and probably to you might be elementary, but it's something that we all need to know. Some of us are from a litigation background and we address the tribunal or the court in a particular way. So the question is this: how are members of the arbitral panel addressed by counsel? Because in litigation, of course, my lord or my noble lords, how are we properly expected to address the arbitral tribunal?
Well, I always address them as a honorable chairman or honorable members of a tribunal, or honorable arbitrator if it's a sole arbitrator. I don't think there is any particular way. I mean, I've not read in any arbitration book on how an arbitrator is supposed to be addressed. But I guess by referring to an arbitrator as a honorable arbitrator or a honorable chairman of the panel, I think it gives the aura of respectability, which I think they truly deserve. I mean, not for any other reason, but it's something I coined myself. And most of the time, people will say, Mr. Shofora, call me my name, even though I'm chairman of a panel. Chairman, Mr. Shofora has said this or so and so. For me, it makes no difference. But honestly, that is how I address. And I think it would be good to ensure that the tribunal members feel comfortable, that at least they're being given that respect.
Thank you very much for that education. There's another bit that we need to understand, and what I would like to know is, the question is this: on this issue of lien on the arbitral award until the fees or expenses have been paid by the parties. There are written codes and there are codes of ethics. And we know that in the arbitration community, you are as good as your last arbitration. And you don't want what to get out that arbitrator or that panel has not published the award. I know the AMA has now said that until fees are paid and expenses are settled, that the tribunal has a lien on it. So the question now is, can you shed more light on the issue of arbitrator placing lien on the arbitral award? Is there a way whereby, from your own experience, you've had that situation and you, instead of having that lien on the award, or now it is codified, there is a subtle way that you have compelled the parties or one of the parties to pay up?
This is not a question of subtle way. This is a question of serious compelling. Because what happened was, it was a 3-man panel, and we had, of course, taken about 60% of our fees up front. And we had the balance of 40% to be paid. Of course, the respondent, who was the losing party, failed, refused, and or neglected to contribute its own portion, because normally fees are normally paid jointly as to half by each party. And the claimant apparently needed the award for the purpose of enforcement. And he pleaded and pleaded and pleaded that he has paid his own portion and we should. And of course, I was not even the chairman. The chairman is also a seasoned arbitrator. And he said, look, the moment we give this man this thing, of course, at that time, what happened? No, we didn't publish. He just suspected that he may have, because the case of respondent was badly presented. And even during the closing, I think that was where it was clear that they did not present their case properly. And because the case was one-sided in any event, one-sided in the sense that the claimant's claims were very, very clear. And there was nothing we could do about it. And we refused to publish the award. And the man begged and begged, was a fairly old man, that we should please publish. And we said no. So he had to go and look for the money. And he paid. And we sent his award. This was about almost several months after the award was ready. Finally paid the balance. And we then published the award to him. And of course, we didn't know what happened thereafter. But I suspected that he must have gone to enforce and he must have been able to get all the money. So that's what happened, I remember. But we insisted that we're not going to release that, we're not going to publish that award. Some people will say yes. I mean, in a lot of books on arbitration texts, you will find that they will say, it is morally unfair for arbitrators not to publish the award. I said, look, it's not a question of whether it's morally unfair. It's a question of there's a lot of work that goes into into preparation, in fact, into the entire arbitral process by the arbitrators. And it is wrong for you to assume that because somebody is an arbitrator and he can really not come after you because of the position he's occupying, that you can write roughshod of the person or take the person for granted. I mean, that doesn't, it's some people in England, in America, they have no other job they do. They're not even lawyers. They're arbitrators and they're noted for being arbitrators. That's what they live on. We lawyers in Nigeria, most of us, arbitration is our second profession. So does it mean that if you work so hard, are you not entitled to be ensured that you get paid? You know, so I was like I said, I was quite happy when I saw Section 54 of the AMA that yes, finally, the moral issue that normally arises in respect of learning of awards for non-payment of fees has been finally laid to rest. So if you don't pay me my money, you won't get your award. Simple. That's it.
Thank you very much, Nancy. I mean, the questions are still coming in fast and steep. We have, and I'm conscious of time. I'll just take two more. One is on the issue of security for costs. And the question is, if the tribunal has ordered security for costs, and the party against whom it has been ordered against fails to pay, will the tribunal continue hearing?
Well, the tribunal cannot stop hearing because if, for example, the person who has been asked to provide the security is a respondent, for example, maybe he has a counterclaim, and the claimant has said, look, please, can you, I know my claim against the respondent is a solid claim, and the respondent is impecunious. And as such, he has filed a counterclaim against me. All right, no problem. Let him provide security for the costs that will arise at the end of the day, so that when I win, at least I'll have recourse. And the respondent doesn't provide security. Are you going to then hold the claimant to ransom and not proceed with his case? Of course, If it doesn't show up, you proceed with the case.
Right.
And if it shows up, it's a contract claim that will not be considered. That's it.
Right. I know that under the English Arbitration Act, if it's the claimant, the claim can be struck out or
Yes.
Yes. So thank you very much for that. I mean, that's a strategic way of dealing with it. And then on a final note, because I am so much conscious of time, what are your final thoughts? You've read the AMA. I'm sure you've been following the past 2 days. What will be your final thoughts on this process, especially to the young arbitrators in Nigeria and getting into arbitration as a practice, what to look out for, what to avoid, what maybe we can call you elder statesman in the industry. What are your final thoughts?
Well, honestly, I think the NBA-ICLE is doing a wonderful piece of work by having this kind of sessions. And there's no doubt that with the situation we have in the courts now, arbitration is the way to go, particularly with regard to a lot of commercial disputes. And unless we have, of course, several arbitration associations that young members can belong to. I always encourage young members of who are interested in arbitration, not necessarily lawyers, who are interested in arbitration after they understand the rudiments of it, to actually take the course, either do the entry course or membership course, as the case may be, in any of the institutions that are available, like Chartered Institute Arbitrators. There's a branch in Nigeria. I think there's the Nigerian Chartered Arbitrators Institute, I think. It's another body. And several other bodies, even if you can afford to go abroad. It's because arbitration is the way to go. And honestly, it will relieve you of the stress that you may encounter, even though some of us have been we are ingrained in litigation, or litigation ingrained in us, whichever way you want to put it, that we cannot really leave litigation alone. But arbitration is also very beneficial, very useful, and people should get trained, proper training. I don't know if Tobena's institute is awarding certificates.
Yeah, Mr. Let us say, I'll take that in the closing.
Yeah.
If you finish answering the question, I'll take it in closing. Yes.
So that at least once they have that, then they can do formal training where necessary in other areas, and they can also become arbitrators, because the field is wide and open. And more importantly, with the new AMA, which I believe has incorporated even more sections which were initially in contention, but it's laid it to rest. I mean, arbitration is likely to develop more in Nigeria, and hopefully, maybe Nigeria will become, or Lagos particularly, will become the hub of international arbitration in Africa. So I think those are my parting shots. Thank you very much.
Thank you, Leonard. So there are so many questions. We've tried to straddle across so many areas of it, even outside your scope of reference, but we'll send the questions to you. You will do your level best to answer them. Again, thank you very much. And yes, this training, I believe personally, has been very, very useful, very educative, and should stand every one of us in good stead. Tobena, thank you very much for this opportunity, and I'll hand over to you now.
Thank you very much, Akin. I'll first of all respond to the poster from the Senior Advocate of Nigeria. So just to mention that the work that we do at the NBA-ICLE is complementary of the work that other training institutes do within Nigeria and elsewhere. But ours is more from the perspective of a genuine interest in our members, creating awareness amongst them, trying to make them understand that there are many fields, many areas, giving them a background, intermediate and master class opportunity to learn at no cost to them, just because we know how difficult things are. But there's also what we think that there is a big disconnect between capacity and prosperity amongst Nigerian lawyers, and that if enough awareness is created and people really understand the true benefits of training and development, especially post law school, then people will know that it is imperative on them to invest in themselves. At the moment, it is for us to create that awareness. Yesterday, we had over 5,000 people log into this program. And that is amazing, because I know that the fallout would be that people will then try to equip themselves by getting institutional certifications going forward. At least anyone who attends this course will have a general background of what arbitration is about, would know, some have piqued their interest. I've received calls from different people saying, what can they do next? And that's why I'm happy that we always end by asking the question, what are the next steps? And the big takeaway from the three speakers that we've had so far is that the young ones to join young people's or young members forums of different institutes, that everybody should interact with those who are practicing in the field, that people should shadow or be mentees to those who are already in the field, which is basically what we should be doing as lawyers. And these kind of sessions also expose people to the leading lights in the profession so that they know where to go and all of that. So I'm grateful that you responded to that question that way, and that I can actually pose that question last. Now to close, Leonard Silk Olumide Shofowara, Senior Advocate of Nigeria, we cannot express enough our delight to you for what you have done today. It is easy for people to take it for granted, the kind of trainings that we receive here, because most people don't pay for it. But I'm happy with the numbers that we've seen today also, and the pick up it was about 1,400. We'll have the statistics later on. But that means that you've given knowledge to so many people, and the numbers have remained consistent. Over 1,000 people still logged in as we speak, which means that people took the value, people are excited, people are interested, and we are now unlocking an opportunity for our members. And we're only able to do it because of the goodwill of people like yourself. I always ask our participants to be extremely grateful to you and other facilitators who take time to do this without charging any money at all to the MBA, despite how much we know, how valuable we know your time is in monetary terms. It was an excellent delivery. I enjoyed it thoroughly myself. I was keen watching the numbers to see whether people were going to drop off, because I know that a lot of the participants here would have been canceling arbitration, but not arbitrators themselves. But this was a paper for arbitrators, and brilliant session today. 2 hours, very excited. I'm exhilarated. Thank you very much, sir, for the honor. It was a pleasure having you.
Thank you, Tobena. It's a pleasure. It's a pleasure. We have to give something to people coming behind us. May God bless all of us.
Amen. God bless you too, sir. And God bless everyone. Thank you.
Thank you.
Yeah. So we continue again on Monday. Greg Falkoff will have a session on Monday. I hope that you all tune in on Monday at 2 p.m., 2 to 4 p.m. to participate. After that, we'll have a session by Justice Abiru, and then we'll close, and then we'll be looking to Akin and the faculty to now tell us the next schedule for the intermediate class. We're delighted that you're participating. Please keep telling members of your branch, your friends and colleagues that there's an opportunity. Go to NBA-ICLE YouTube, subscribe. We have over 100 sessions there now, all there for free and for value. So thank you very much. God bless you all. And I also thank Akin Omisade, coordinator. I thank Rachel Osibu, thank Peace Adeleye, then from the MBA and Sarah Adijola and Wole Efuope. So thank you very much, everybody. Thank you.
Thank you, everyone, and have a good day.